has ordered that the summations not exceed more than 30 minutes. Respondent will proceed first, followed by the appellant, and because respondent has the burden of proof, respondent may reserve time to do a final summation. So you may proceed, Mr. Lee.
Thank you, Mr. Chair, and thank you, Mr. Vice Chair, both of you, for reviewing all of the documents and evidence that we've given you with an open mind. This is a serious case, and there are serious consequences for Commander Minor and also serious consequences for the city. Integrity is the most important value that a police department can hold. And integrity is especially important for internal affairs because internal affairs is how a department polices itself and proves it's worthy of the public trust. The city is here today because it believes very strongly that Commander Minor violated the integrity orders that he intentionally withheld and misled from internal affairs investigators. And as we go through the evidence that I've prepared for you, we'll see that this is not, in the city's view, a close call. The first thing I want to talk about, because you'll be asked to make a finding about it, is just cause. Just cause is defined by statute, but I'll go through very quickly so that you can see that all of the requirements for just cause have been met. The first one is, was there a written rule or order informing the officer of what standards he is to live up to? The general orders and administrative regulations have not been challenged, and that element is not in dispute in this case. The second issue under just cause is whether the discipline is related to the officer's core standards or the department's mission. And I don't think we have any dispute there that integrity is central to performance of a police officer and central to a police department. The third issue is whether it's more likely than not that the officer violated any of the general orders or administrative regulations, and we'll talk about that in detail. And the fourth element is whether the discipline is excessive, if it's reasonably related to the seriousness of the offense and the officer's service record, and we'll talk about that too. We've spent a lot of time in this hearing talking about the conduct of many other officers in the department, but it's important that we focus now at the end on what Commander Minor did. There is substantial evidence in this case that Commander Minor failed to answer truthfully and completely, that he did not disclose all facts, and that at the end of his first interview with Internal Affairs, he had related a misleading account of the incident. This is a strict standard, but there is no requirement under the standards to prove any motive or specific intent. That's not part of the standard. If you know something and you don't say it, that is an integrity violation. I'll talk very quickly about due process. There have been some comments about that throughout this case. The department complied with all the procedural requirements. Commander Minor was given a notice of investigation each time he was asked questions by the department about the facts of the incident. He was entitled to 5 minutes to speak on his own behalf in his investigation, and he was allowed to speak for 20 or 25 minutes. There's no issue with the process requirements. There has been a process argument that, well, somehow the results of the Internal Affairs investigation were preordained. And if it feels like that, it's because of the facts. This is the most well-documented case of misconduct that I've ever seen, just in terms of how well-documented all of the facts are. We have transcripts of all the participants. We can all look and see for ourselves. And while we do have some disagreements, it's important to note where we all agree. We all agree that in the meeting, when Lieutenant Bonnet heard the comments, he was offended. And we know, and we agree, that Commander Minor knew it before he walked into that first interview. We agree that Commander Minor, in real time, during the meeting, received a text message of shock and outrage from Lieutenant Bonnet, and that Commander Minor knew it when he walked into the interview. We agree that Bonnet is the only person who called Commander Minor right after the meeting to talk about the comments and his reaction to them. We agree that Bonnet lodged the complaint with Commander Minor as his supervisor, that Commander Minor elevated that up his chain, and that Commander Minor followed up with Chief Pop over the next several weeks about the status of that complaint. None of these facts are in dispute, and all of these facts were known to Commander Minor before he sat down in his first interview with Internal Affairs. And the last and most important thing that we all agree on is that he did not share any of this information with Internal Affairs investigators. There are some other facts that Commander Minor knew before he walked into the investigation. We know that immediately after the meeting, Commander Minor got to work. You have this presentation in your exhibit notebooks, but as soon as the meeting was over, Commander Minor talked to Lieutenant Bonnet, as we mentioned. But he also talked to Commander Leduc in the week following. The day after, he talked to Chief Pop. He talked to Commander Henny, Lieutenant Walther, Army, Carrera, a number of people there and not at the meeting. Commander Minor spoke to all of them relating what happened and found out their responses. And he later provided all of these materials to Internal Affairs after he was confronted about not coming forward. At best, this is Commander Minor doing his own investigation about the response to the comments. And at worst, this raises a question about whether he has an issue with AR 333 for gossiping. He's sharing these accounts, and you can see for yourself in the notebooks what those conversations consisted of. But this is a concern. And all of this background, all of these conversations happened between the meeting itself and between Commander Minor's first sit-down with Internal Affairs. And Commander Minor did not share any of this with Internal Affairs either. So we get to the day of his interview. He knows all of this. He's sitting down. It's his chance to go on the record. And IA asks him about offense. It might be asking some other things, and we'll talk about the definition of words, but certainly they're asking about offended people in some classification. And Commander Minor shares none of this. Instead, he answers, I don't know specifically. He doesn't say he's done his own investigating. He doesn't say he's been talking to other people. He doesn't say he used chain of command with Bonnet. He doesn't say it at all. However, after he got caught and was asked to account for this discrepancy, he says, I thought it meant two things. I thought it meant targeted and offended. So that means I give you no names, and that's fine. But that's not the standard. That's not the standard to provide all facts to Internal Affairs. If Commander Minor truly believed that this is a two-part question about, they're asking me about targeted and they're asking me about offended, he should have given Internal Affairs the names of all of the people he spoke with, who he knew were targeted or offended. And he did not come forward with that information. But I don't know specifically is not the worst part of Commander Minor's answer. He's asked, do you know of anyone in particular? And he says, I don't know specifically. But he goes on. He describes it was definitely an uncomfortable laughish during, after. That's not what happened. Some people did. But with this answer, Commander Minor has told Internal Affairs he's offered information about what the response is. And whether or not he was asked, he makes this statement. And that's not accurate, because that's not all that happened. This is a lie by omission. So we get to to the end of the interview, and Commander Minor allows it to end and never shares the list of people who were targeted and the list of people who were offended. He misrepresents what the general response is, despite the fact that real time in the meeting itself, he receives the text, so he knows that this is not accurate. And it's not about something that came after, although he does represent that this uncomfortable laugh was during and after the meeting. And he walks out. And now we show up to this hearing, and Commander Minor is asked, well, what about off the record? Well, Sergeant Galahar and Sergeant Lewis testified. Off the record, Commander Minor did say, I want to talk to you about Chief Rodbell's handler. And their testimony is consistent, they couldn't remember direct words. And there's no statement to the contrary in any of Commander Minor's presentations or materials. That's not come up. He wanted to talk about Rodbell. However, in this hearing, an hour ago, on questions from Commander Minor's counsel, he was asked 4 times, what did you tell Sergeant Lewis when the tape was turned off? And 4 times he said, Pop, and Bonnet, and Rodbell, Pop. And it wasn't until the 5th time, when I asked him, that he acknowledged he did not use Lieutenant Bonnet's name, he did not use Chief Pop's name in that conversation. In the end, the argument that we've been seeing in this case does not make sense. The argument is, well, you should have asked me the exact right way. Directly offended, well, that's too specific. Asking me if I have anything else to add, well, that's too general. You have to thread that needle exactly right if you really want to know what I know. But that's not what the orders say. The orders say all facts. And the orders say you don't mislead. If you're doing this, if you're talking and parsing about word definitions at this level, you're already across the line. Counsel has raised an issue about potential motive, and the only one who could tell us for sure is Commander Minor. Perhaps he is worried about getting in trouble or having IA find out he's been having all of these side conversations. That might be. It also might be that he's offended at even being asked the question and felt like, well, it's not fair. Why am I put on the spot for other people? Or why should I be on the spot to talk about whether it's offensive or not? And we see that too. There's no dispute. He said it was absolutely correct what Chief Pop told Mary Cronin, that Commander Minor said, I shouldn't have to tell you why I'm offended. And that's his opinion. And he walked into an interview and he thought he shouldn't have to tell you. And he didn't. And later on, he thinks, he reflects, he spends 13 days after his interview thinking about being complete. And he sends an email. And the email is entirely about Slavin. And none of it is about himself. And just for the sake of argument, if we're looking at how Slavin and Minor conducted themselves during internal affairs investigation, questions from counsel seem to suggest that, oh, well, I can't offer information in IA. I can't just volunteer. Of course you can. And in fact, that's what Chief Slavin did. If you look at his interview transcript, there's no question from IA that even starts it off. When Chief Slavin talks to internal affairs, he says, so I'd like to tell you about the meeting. They say, okay. Right at the very beginning, this is at the bottom of the first page, he says, I'd like to tell you about the meeting. And he talks, and he talks. Internal Affairs doesn't even ask him any questions about the meeting until the bottom of this page. And that is how forthcoming we need to be with Internal Affairs. don't play word games with internal affairs. There are some issues with people have different memories. People don't recall. People don't understand quite, what did I say? Oh, did I say that? I thought I did. It was in the narrative. Or, I don't remember hearing. And the city does not discipline for paying attention or recall or memory issues. And Commander Minor identified a number of people who did have issues with memory or recall. The standard isn't verbatim, and we're not expecting that, and we're not holding Commander Minor to that. The standard is what you know, you say. And he did not do that. We already talked about the issues with, if this is a two-part comment, can you answer with no information versus the information for each part? But there are some deflections that have come up, both in the second IA interview and in this hearing. And one of those deflections from the issue of what did Commander Minor say is, well, what did they know before they talked to him? And we've made inquiries about that, including the board chairman's inquiries to Commander Minor just before this part of the hearing. And at first he suggested, oh, I assumed. That's not what he told IA. IA went through a list in his second interview and asked him to confirm, what did you know before you came in? And Commander Minor affirmed on the record already he knows that IA is going in cold. The other deflection is, what did IA do after Commander Minor's interview? Well, I knew you were going to talk to other people, so that's why I withheld the information. That's the argument that he raised in his second interview, where he said, quote, didn't you tell me you were going to interview everyone else there? No, not before he misled them. They asked him the question, directly offended. He talks about the uncomfortable laugh. He says, I don't know specifically. That answer came out before he was told that IA would be interviewing everyone there. And they're deflections because none of this matters to the standard that Commander Minor must live up to. But when we get to the second hearing, and we get to here today, there's another issue that the withholding and the mischaracterizing and the misleading, it doubles down. And in the second interview, Commander Minor, again, doubled down and told IA on the record, oh, I didn't tell you in response to a question about why he didn't talk about Lieutenant Bonnet. He says, no one in particular stood out. That was his pre-decided answer to that question. He put it on a slide and then he brought it into the hearing and he testified consistently at that. No one stood out. And we know that's not true. For the obvious reasons we've already talked about. And because of the fact that Lieutenant Bonnet is his close friend. And Commander Minor read the interview transcripts before he walked into IA. It defies belief that nobody stood out under all of the facts we've learned in this hearing. In the end, there's no such thing as a white lie to police internal affairs. And there is no such thing as no harm, no foul when talking to police internal affairs. All the arguments we've been hearing about, well, it was before vacation, well, the interview was short, well, he didn't ask it exactly right. None of that has anything to do with Commander Minor's obligation. He had an obligation to come forward and say what he knew. And if he had whatever motive he had for holding it back, that doesn't excuse it. We've had a lot of criticism and a lot of focus on this hearing about people who are not Commander Minor, who spent what seems to me like most of this hearing talking about Chief Slavin and what did he do, and what did he think, and what did he try. And Chief Slavin is not here, he's not on trial, and he didn't have a chance to defend himself in this hearing. And I'm sure he would have his version of the story that he would like for everyone to know. But even if you have any concern about anything that Chief Slavin did or didn't do or said or didn't say, you've already heard undisputed testimony that the decision to open an IA and the decision to go forward was made entirely by Chief Rodbell. Chief Rodbell said that to us on the stand, and he is the person who is responsible for reviewing the transcripts and making the decision to go forward. And I think he did testify that his decision was based on nothing more than his judgment as a police department chief of however many decades, as a chairman of Basic Post, that this transcript caused a problem, and he decided for the integrity standards of his department that this had to be looked into. When Chief Rodbell testified, he freely acknowledged Commander Minor's service record, and we absolutely do. This is, we've never seen anything like this from Commander Minor, and no one at all questions his history as an officer with the city. Chief Rodbell himself testified that two out of three times Chief Slavin and Commander Minor were up for jobs, the same job at the same time. 2 out of 3 times the chief promoted Commander Minor over Chief Slavin. Chief Rodbell also told us that he had been trying to set Commander Minor up for the next assistant chief opening, to give him assignments that would round out his resume, to try to develop him so that he could advance in our department. Chief Rodbell is a tough chief with high standards, and accountability is not popular. But in the end, there's been no evidence that shows that Chief Rodbell has tried to retaliate or had any improper motive toward Commander Minor. And in the end, there was testimony that Chief Rodbell, in trying to find out if Commander Minor wanted to go forward, was trying to spare him and trying to make sure that he had the options going forward in light of all the evidence that we know. So I don't believe the evidence supports any retaliation finding that has anything to do with this case, but even if you did, that's no excuse on integrity. The standard is the standard, and just cause does not mean that you get to lie if it's in pursuit of some larger goal or different idea of justice. And the standard doesn't mean that you get to lie if IA asks you a weird question or has an aggressive tone. You don't get to mislead IA if you want to stay above the fray or you don't want to share all these side conversations you've been having. And you don't play word games. If you think it's in 2-part questions, you give the answer on both parts. That brings us to the last element of just cause. Is the discipline not excessive and reasonably related to the seriousness of it? And the evidence that we have shown you is undisputed. Integrity is so central to the performance of a police officer that if you have a sustained integrity violation, the city of Scottsdale's policies, you cannot be an officer in Scottsdale. You can't put people in jail on the word of an officer with a sustained integrity violation. This is a terribly unfortunate situation, and nobody wanted to be here. Commander Minor had a bright future in the organization that the organization was planning on for him. But in that moment, he chose wrong, and he didn't fix it in the interview. He didn't fix it after he never voluntarily came forward and tried to correct his error, his affirmative statements that misled, his withholding of information from Internal Affairs. And when asked, when confronted, the response has been that it's everybody else's fault. But in fact, the integrity standards for the city of Scottsdale, they require more, and just cause does support discipline. Thank you.
Counsel, I have exhausted. How many, I see you have a time, how many minutes do you have?
I have 5 left.
Okay. That's good. I'm not taking your time, I would ask, I think I said this at the outset of the hearing, the panel, the board, they want to ask some questions. Does the vice chair have any questions?
I do not.
I think I only have one, but in the evidence, Sergeant Lewis informed Ms. Galahar said in his report whether anyone who was offended was not relevant. There's the fact you raised here, appellant's response saying I shouldn't have to tell why I'm offended. Does the nature of the question, would the nature of the question allow someone to not tell the truth if it's an important question?
No, and if I could.
Well, please, no, it's not coming out of your time, so take as much time as you.
The question of, is this an important fact? It's not necessary to sustain each particular element of an AR 333 violation. But we've heard from all of the officers today, the dynamic, troop morale, gossiping, these concerns and these feelings of offense. This is important to the department to figure out where do we have an issue and where do we need to put our attention to fix it, to remedy, to make sure we're communicating with officers. So whether or not that question is relevant to a specific AR violation, it is absolutely important to the department. IA has the right to ask that question, and no matter the reasons, if you hold back and if you mislead, then the standard is the standard.
Well, here's another question. What if Sergeant Lewis asked another officer who was at the meeting, were you offended because you were gay? And the person who's not revealed themselves as being gay said no. Would they be subject to termination for lying to an IA investigator?
Those are not the facts in this case.
I know, but I'm
and
trying to find, because and I apologize for interrupting, sort of try to preface that with, because the investigation questions, the appropriateness of how to answer the question has come up, which goes to the question of, I guess, knowledge and integrity. Try to find out if it's an absolute.
It is.
So if a person who has not revealed their LGBTQ situation, that if they fail to reveal that in an IA investigation, they could be terminated. Is that the position of the city?
The position of the city is, under this hypothetical, if an investigator asks an abusive question like that, the standard is the standard, and you cannot lie. And the city would absolutely take action against the investigator for asking a question like that, because I agree with you, that would not be appropriate. But absolutely, the standard is the standard, because you can't run a police department. You can't condone or wink at officers deciding on the fly in an investigation with internal affairs. Well, I don't think this is important, or I don't think that is important. If you do that, and if you condone or at all allow that conduct, you effectively rob the department of any way to police itself if you do that. So yes, the standard is absolute.
Does the deputy chair, the vice chair, have any follow-up to my question?
I do not.
Thank you. You have 5 minutes left, I guess we'll do switch.
Did you want the workstation wiped down first?
paperwork down?
Oh, you're ready? Do you have a timer?
I do.
Okay. You can begin.
Members of the board, Commander Minor was the conscience of the Scottsdale Police Department. The conscience is aware when something's wrong. It reacts first, even when others don't react or when others remain silent. Here, Commander Minor heard something wrong and he reacted. He told his supervisor, Chief Pop, but he also told the person who said the wrong thing. He spoke directly to Chief Slavin. Commander Minor also knew the rules of the city of Scottsdale. He knew AR 333. He knew that discriminatory comments should be handled by policy in a certain way. So when Commander Minor heard from his supervisor that Chief Rodbell handled the Chief Slavin comments without a formal investigation, Commander Minor, the conscience, knew that this was wrong as well. But consciences can be treated in different ways. They can be ignored, they can be valued, or they can be targeted for the truth that they try to reveal and be forcibly silenced. So let's talk about what happened here specifically, which is the allegation that Commander Minor deliberately covered up misconduct for someone that he supposedly didn't like. I'd like the board to consider this prospect. Chief Rodbell knew how to dog whistle. He knew how to send a signal that wasn't overt, but was perfectly clear. At the beginning of the investigation into Chief Slavin, Chief Rodbell dog whistled to Chief Pop. I know that Chief Slavin made homophobic remarks. I know that Chief Slavin violated AR 333. I know that Commander Minor and Lieutenant Bonnet have concerns about what happened. But I'm signaling that this investigation is over before it starts. It's a verbal counseling. Chief Rodbell actually didn't dog whistle to Damian Mendoza. He was very clear. Thanks for the concerns of your membership. Thanks for letting me know that members of the Scottsdale Police Department take issues with homophobic comments. I'll investigate it if you want, Damian, but nothing's happening here. We have every reason to believe that Chief Rodbell dog whistled to Sergeant Lewis in Internal Affairs. We believe this happened at the beginning of the investigation. We believe this is why Chief Slavin's NOI only addressed one comment made by Chief Slavin when Sergeant Lewis was in possession of a complaint which clearly articulated two comments. We believe that this is why the investigation into Chief Slavin was categorized as an AR 333 Part 2 violation, even though his comments had a direct nexus to sexual orientation. Chief Rodbell sent a message to IA that he'd already handled the misconduct, so all Sergeant Lewis needed to do was identify the offended parties. The investigation will lead nowhere. So when Commander Minor entered Internal Affairs, he did so with the benefit of his experience as a former IA investigator. He knew his role was to answer the questions he was asked honestly, as he best understood them. But Commander Minor knew that it was in fact possible that IA investigators were asking certain questions in certain ways. Because remember, at this point, Commander Minor knew that there was finally an investigation. He knew that everyone would be interviewed. He knew that his prior report to the chain of command, and he knew that Rodbell was well aware of that. So with this knowledge, with these questions that he was asked of directly offended, he believed that IA wanted to know just that. Are you aware of anyone who is directly offended? His answer, specifically no. The Vice Chair in his questions to Commander Minor laid out the things that come into his mind when he hears the term directly offended. Make no mistake, I wish that Commander Minor's mind worked in that way, because we wouldn't be here. But the board has clearly heard that Commander Minor was not trying to hide his offense. Commander Minor took his offense to Chief Slavin and to Chief Pop. Commander Minor was not trying to hide the offense of Lieutenant Bonnet. He took Lieutenant Bonnet's offense to Chief Pop at least twice. So while the Vice Chair takes a different path when he hears the same words that Commander Minor did, that doesn't mean that Commander Minor intentionally lied or intentionally withheld information. The intention matters. Commander Minor's actions must be considered when evaluating and judging him on the intention behind his responses. The City's Council told this board that intent or motive are not a requirement to sustain the misconduct finding being evaluated today. First, I submit this is for the board to decide. But second, it's important and telling that opposing counsel took the time to tell the board this information. We believe the reason lies at the heart of this entire matter. There has never been, and will never be, a logical or illogical reason for Commander Minor to intentionally lie or to provide misleading information. They know this, you know this, and remember this. But just in case Commander Minor had heard things wrong during his interview, just to be safe, once Commander Minor responded to that weird question, asked twice in a weird way, Commander Minor clarified. He asked, do you want to know what happened about how this was reported? Do you want to know how Chief Rodbell handled this? The answer from the IA investigator, nah, Commander, we don't need to go back on tape. Now, much of this hearing has been around the importance of words. We'd like to ask the board to look at Sergeant Galahar's recollection of Commander Minor's words. We'd like them to focus on two of the words that Sergeant Galahar remembered, how this was reported and how it was handled. The counsel for the city in her closing told the board that Sergeant Galahar did not remember exactly what was said. That's true. The counsel for the city told the board about the word handled. The term reported, which is in the transcript that the board has reviewed, was omitted from what the city's counsel told the board just moments ago. The only reporting that Commander Minor was a part of prior to his interview with Sergeant Lewis was to Chief Pop. The only person who handled this investigation prior to Commander Minor's interview with Sergeant Lewis was Chief Rodbell. And we want to make sure that one other part of this portion of the record is not lost on the board. This is not a self-serving statement made by Commander Minor about his conduct after the fact. This was a statement by the co-investigator in the integrity investigation against Commander Minor. Commander Minor does not need to tell you that he provided or would have provided information regarding his reporting related to Lieutenant Bonnet, Chief Pop, and Chief Rodbell. Sergeant Galahar did that for him. Now, this conversation is actually undisputed. Sergeant Lewis didn't deny it. Sergeant Galahar provided it to Mary Cronin, who promptly ignored it in her report, and Commander Minor testified about it here. No one testified against it. Commander Minor asked and actually confirmed what IA was and was not looking for. The counsel for the city talked about there not being a standard of no harm, no foul in internal investigations. But that's not totally true, as the record shows. Interviews can be incomplete, as Chief Slavin's was, and IA can clear that up. No harm, no foul. And Chief Pop recognized that Commander Minor had no reason to lie. He had made previous disclosures, and his answer appeared inconsistent. Yet Chief Pop's position was that an IA was not warranted. You heard something about if you don't understand a question or if the question isn't good enough, you have an obligation to put out all facts. Did all witnesses in this case put out all facts? Or is there a different standard being applied to Commander Minor? And I'll come back to this later, but let's have a thought experiment right here. Had Commander Minor asked this question on tape, you want to know about how this was reported, you want to know about how Chief Rodbell handled that, if that question was captured on tape, would we be here today? Is he really being labeled a liar and lacking integrity, deliberately lacking integrity, when he clarified immediately after the tape went on? Now, in addition to the dog whistling from Chief Rodbell that occurred at the outset of the Chief Slavin investigation, there is clearer evidence to show that same conduct from Chief Rodbell related to the Commander Minor investigation. Remember, Chief Pop went to Sergeant Lewis to get the transcripts and the audio from the interviews. Chief Pop specifically addressed his concerns about the manner in which Sergeant Lewis conducted his interview with Commander Minor. Chief Pop did not believe that Commander Minor intentionally lied or deliberately provided misleading information. Traditionally, Sergeant Lewis would report the findings of his internal investigations to Chief Pop. Chief Rodbell was clear to Sergeant Lewis from the outset that all communications regarding the Commander Minor investigation would bypass Chief Pop and would be reported directly to Chief Rodbell. The dog whistle. If you don't agree with Chief Rodbell's conclusion that Commander Minor lied intentionally and deserved a sustained integrity violation, you're out of the conversation. Sergeant Lewis reached the only conclusion that he knew would pass muster with Chief Rodbell. And there's one final dog whistle that occurred here. Commander Minor offered to go back on that record to expose how Chief Rodbell handled the Chief Slavin misconduct investigation. Sergeant Lewis chose not to take the path of integrity or transparency or all relevant facts. Commander Minor knew the drill. He was brought in and told to take your money and go away. He was told at that time, it's in the record, you have no appeal rights. That there's $70,000 of sick leave and your state certification at stake. You can just walk away quietly, and this will all end. But integrity doesn't respond to dog whistling. Commander Minor would not lay down for this hit job. He would stand up for what was right, like he did his entire career. Not only did Commander Minor expose Chief Slavin's misconduct, he exposed every member of the command staff that may have been complicit in allowing a culture which enabled inappropriate and homophobic comments and stereotypes to go unchecked and undisciplined, to be buried. This moral fortitude cost Commander Minor his career, potentially. He was forced to go through protracted litigation to pursue the truth, a transparent evaluation of his actions, and the actions of other members of the command staff of the Scottsdale Police Department. And he wants to come back. He wants to continue to make it better. Because at every turn, Commander Minor's integrity has come at a cost. It's come at the cost of popularity with peers. You will name everyone that you believe provided a false or misleading statement in this investigation, and you'll do it in writing. Enjoy that, Commander. It's come at the cost of his financial well-being. It's come at the cost of his reputation in the community that he fought so hard to serve. It's come at the cost of his mental and now physical health. This board should know, unless they overturn Commander Minor's discipline fact findings, that cost will continue long after this hearing. A sustained, deliberate integrity violation finding will cost Commander Minor his ASPO certification. Hasn't happened yet. That finding will stand or fall after this hearing. A sustained integrity violation finding is a death sentence to Commander Minor's career as a peace officer. Hasn't happened yet. That'll pen the result of this hearing. Because this hearing is his opportunity to set the record straight, to fix these factual errors in the report as it sits that would otherwise impact Commander Minor for the rest of his professional life. Commander Minor was the conscience of the Scottsdale Police Department. He chose to take on that role. He chose to act when something wrong occurred. That being said, with the benefit of 20/20 hindsight, Commander Minor does wish that he had taken the opportunity in his first interview with Sergeant Lewis to give a better explanation of his actions after the command staff meeting. Never in a million years did he think he would be here, but Commander Minor was never trying to hide the fact that he'd made a complaint to Chief Bob on behalf of himself and Lieutenant Bonnet. But Commander Minor does concede that he did not make the offer to address these facts until after the recorded interview was concluded. Although Commander Minor steadfastly maintains that he did not lie or deliberately provide false or misleading information, Commander Minor believes that he could have done better. Commander Minor would willingly accept a recommendation by this board for verbal counseling, the same discipline that Chief Rodbell chose to give Chief Slavin for his homophobic comments, and a verbal admonition to provide more complete answers during internal affairs interviews, even if that wasn't the question that you were asked. So there's an important parallel here too. You, the personnel board, are by charter definition the conscience of the people of Scottsdale. You, the members of this board, will define through your recommendation how this story is told. The investigation into Chief Slavin was flawed. The questions asked to Commander Minor were unusual. And through everything, the city has failed to present any evidence that Commander Minor had any motivation to deliberately withhold information from internal affairs. Additionally, the evidence is clear, and thank you both so much for reviewing this to the level of detail that you have, because I can say this conclusively without having to go through elaborate testimony. The evidence is clear that Commander Minor was asked different questions than others. His answers were scrutinized very differently than the answers of others. And this investigation into Commander Minor was undisputedly instigated by Chief Slavin, the very individual whom Commander Minor addressed as having engaged in inappropriate conduct. In contrast, and even though we do not have the burden, we presented uncontroverted evidence that Commander Minor is and has been a man of integrity. We presented uncontroverted evidence that Commander Minor brought concerns forward and even followed up when those concerns were not addressed appropriately. We explained how Commander Minor understood the questions that he was asked. Because Commander Minor acted with integrity, he should not face termination and the ruining of his law enforcement career. The board has now heard the evidence. We believe that the board has the ability and the obligation to make findings which are supported by the evidence. We would ask the board to find the following. 1, that the Scottsdale Police Department did not properly handle the AR 333 violation by Chief Slavin, both because they did not investigate it initially and because they improperly investigated it through poor procedures and questioning once the investigation was initiated in internal affairs. Finding number 2, that Commander Minor's actions as a supervisor and as a witness were consistent with the requirements of AR 333. 3, that Chief Slavin knew that Commander Minor and Lieutenant Bonnet had brought forward concerns related to Chief Slavin's inappropriate remarks very shortly after the patrol operations meeting. 4, that Commander Minor did not deliberately lie or deliberately mislead investigators during his internal affairs investigation. Because that's the standard, deliberate. Could he have done better? Absolutely. Never in a million years were his words did he ever think that this would be the finding. Number 5, that Commander Minor answered the questions he was asked truthfully based upon his understanding of the questions at the time. Number 6, that Commander Minor's request to go back on the record after his initial interview should have been granted. Number 7, that Commander Minor provided a reasonable and consistent explanation for the miscommunication in his first interview with Sergeant Lewis. Number 8, that Commander Minor provided truthful and complete answers during his second interview, which is the integrity investigation. Number 9, that Commander Minor fully alleged the integrity investigation he faced was retaliatory in nature, and that retaliation was not properly investigated. Number 10, that just cause does not exist to terminate the employment of Commander Minor. And number 11, that Commander Minor should be reinstated to his prior rank within the Scottsdale Police Department. Finally, and with all sincerity, thank you. Thank you for volunteering your time. Thank you for agreeing to hear important matters like this. Commander Minor has waited for months for the opportunity to address the allegations against him, and he looks forward to your recommendations.
Does Vice Chair have any questions? I have some clarification. You were asking us to put them down 1, 2, and 3, how Proctor handled the AR-330 investigation. I can't read my own handwriting. It's the second one, the third one, the chief they were there on his concerns. Then I think it was 9 retaliation. Are those? I'm sorry, I'm going to have to start because that's the questions. You set forth 11 different items. Briefly, I think 1, 2, and 3, not properly handling the investigation, minor, the Collins actions consistent with the AR-333, the chief being aware of the Collins and Lieutenant Minor's concerns. 9 being retaliation. Are those matters properly before the board? I thought the only thing the board could do was to address whether he did not lie or mislead, whether he was truthful. It's 4, 5, 6, 7, I think 8, and there's a question of reinstatement, which was cause. These other things, are they really matters within the board's jurisdiction to address them? So I thought we said earlier there's not.
Well, I believe that the board is considering very carefully all the evidence in front of it, including reports and recommendations related to Mary Cronin. And as part of this appeal, these factual findings that I laid out, and which the board can accept, reject, or modify, obviously, would provide context for the city manager to be able to understand your reasonings behind the decision. So are they necessary for the finding as to whether the discipline is going to be sustained or overturned? No. Would they provide appropriate context that I think that the reviewer of your decision would be able to consider? I think it is properly before you. I'm sure that my friend, counsel for the city, may not want you to address those things, but I think that you're perfectly competent to do so, that you've heard the appropriate evidence, and that in your role as the keeper of the conscience for the city of Scottsdale, that those issues are properly before you.
Vice Chair Stokely, do you have any follow-up questions based upon my questions?
Yes, but I will present that my findings of that.
Okay, thank you. Does the attorney for the city have any follow-up? And since the counsel for the appellant is completed, you can go sit up there and we'll not take your 5 minutes.
Thank you. And if I could just have a minute, my computer laptop was closed, so I just need a second to
Sure.
start it back up.
And do you have those 11 items written down somewhere if we need it?
I do.
Okay. period provided during the court deliberation.
I will.
Are you ready, counsel?
I am.
Okay, first, could you just address the question of what items are appropriate for the personnel board to consider?
Certainly. If you review your enabling statutes and what the scope of this type of hearing is, the issue is just any facts necessary or not necessary to sustain the discipline, and it's not appropriate to make findings against other people who have not had procedurally any ability to defend themselves in this case or call witnesses. So that's outside the scope of this hearing, and when the city manager reviews it, he has all the same records and binders that you do, so there's no need for context. That's not a requirement, and it's not appropriate within your scope.
Just to be clear, thank you for providing, I guess it's the city's position, while the police department, and if the board needs to, the board knows where to go for this information. Thank you. You have 5 minutes.
The evidence in this case is the evidence, and the standard is the standard. As you make your findings, in fact, I encourage you to look at the words in the general orders that apply to this case, and you'll see that there is no intent requirement. However, we did provide some possible reasons that Commander Minor may have wanted to hold back, whether it's not wanting people to know or get in trouble for his independent investigation or all of these side conversations, or the fact that he said he didn't want to have to answer the question. We've heard many times that it's weird. But again, this illustrates the whole problem with having some kind of flexible standard or condoning or winking at people in internal affairs investigations, holding things back or playing games. And the most important thing that has come out of this entire hearing process, the most important thing that we've heard, is that Commander Minor said what he said on purpose. Right or wrong, he said what he intended to say. He's never said, I misspoke, I forgot. He chose to give the information he gave, and he chose knowingly to hold back what he chose to hold back. And now it's up to the board to decide whether that meant clear, articulated, absolute standards that are set forth by the city. We do have our own proposed findings. I apologize, this is very, very short, or very small print. A lot of this, I'll just read them really quickly with my last few minutes, and we can refer back later on.
Those right.
I will try to print them if we take a break, my portable printer broke, but,
Perhaps you can email it to each other.
correct. So, quite simply, our proposed findings, we're not asking you to go outside of the record or outside of the discipline in this case, or say anything at all about Commander Minor or his character or as a person. That's not what we're saying. But very discreetly, again, what we talked about, we asked you to find that Lieutenant Bonnet was offended, that he sent a text, that he called on the way home, that he lodged an AR-333 complaint, that Commander Minor elevated that complaint, that he followed up with Assistant Chief Pop, and that he did not share this information with IA at his first interview. And those facts are not in dispute. The other fact findings that we ask that you make are that no other witnesses who were interviewed in the IA investigation informed investigators that Assistant Chief Pop might have information. And again, that finding is supported by your transcripts. You can look and see that that's true. We ask that you find that in that first interview, in response to a question about directly offended persons, Commander Minor interpreted that question as a two-part question, but failed to clarify that before answering, and failed to offer up the names of people he felt were targeted or offended. We ask that you find that Commander Minor lied about his knowledge regarding how the slavery comments were received. When Commander Minor described that response as an uncomfortable laugh, when he knew full well, contemporaneously, that there are people in that room that are not laughing, who are texting him right then with shock and outrage. We ask that you find that Commander Minor misrepresented himself to Internal Affairs when he said no one in particular stood out as offended in that second interview, which is not plausible based on everything we've learned about his contacts with Lieutenant Bonnet. And finally, as a matter of the Peace Officer Bill of Rights, ask you to find that the City of Scottsdale informed Commander Minor in advance that these are the standards through rules in effect, including Scottsdale Revised Code Section 14-72 and General Orders 1411, I forgot the other one, I believe is 2032. But essentially that those orders that are in his termination notice were in effect at the time that he took the contract. So, again, the evidence is the evidence, the standard is the standard. We agree that this is a very, very unfortunate situation, but we ask that you allow the city to uphold its standards for integrity.
Thank you. Anything further from the city? Ms. White?
No, thank you.
Anything further from the appellant?
No.
Okay, at this time, we set forth that item 4 of the amended notice of agenda. We have our time for deliberation. Before we begin our deliberations, does the Vice Chair want to make a motion to go to recess or to go into executive session to discuss and consult with the board's attorney for legal advice regarding procedure, evidence, burden of proof, and other matters properly discussed in executive session as set forth in the amended notice of agenda?
I do not have that need. I would, however, like a 10-minute break before deliberations begin.
Certainly. I do have I do think we need to go into executive session briefly, and I think we can do that during this break. So let's, can I have a motion to go to?
Oh, I'm sorry, you need to have a motion.
I have one.
I motion for executive session to begin at 2:45 and